And you know what? It gets a little complicated. And that's why oftentimes judges and attorneys get it wrong. And definitely the public gets it wrong. In fact, I would say most people get it wrong. This video is about what constitutes community property when a person dies in Texas. And I had to make this video because there are so many misconceptions about community property when a person dies. So first of all, let's get out of the way what community property is generally. Community property is basically anything that a married couple owns together. And we actually have here in Texas a legal presumption that when you pass away and you're married, everything that you own is actually community property. And community property means 50-50. So let me just give you an example. Let's say that you have a husband and wife, and then the husband dies, and together, before he died, they had a house and 2 cars and some bank accounts. Well, the legal presumption is that all of those things that I just mentioned, they're community property. And community property means half owned by the wife, half owned by the husband. That's the legal presumption. So what that really means then is if the husband died and his will says, I give everything to my children, well, everything only includes his community half of all of those assets. So that would be half the house, half the cars, half the accounts, half of everything. His community half would go to his children pursuant to his will. And you might say, well, wait a minute, Isaac. And here's the first misconception. If you're married, doesn't all of the community property automatically go to the surviving spouse? And the answer is no. Not only is it not automatic, but it might not go to the spouse at all. That's because if you pass away with a will, then the community property goes where your will says, or your half of the community property goes where the will says, not to your surviving spouse. It's certainly not automatically. There has to be some sort of probate process to deal with the deceased person's assets, whether that's through a will or through another legal process called a determination of heirship. Your assets will go through probate if you're married, and your community half will go to the people that you've designated or to your heirs at law. That could be the surviving spouse, but that's not a guarantee. And like I said, it's certainly not automatic. But while there's that legal presumption that all of a married guy's assets are community property when he died, that does not necessarily mean that everything truly is community property. That's just the legal presumption. But the legal presumption doesn't tell the whole tale. That's just a presumption. That just means it's presumed. That presumption can be rebutted. So for example, let's say in that same scenario, you have a guy who died, he was married when he died, and there were 2 cars and a house and then some bank accounts. Well, let's say the title to that house shows that the husband actually bought the house before the time of the marriage. Well, in that case, that title would show, hey, the presumption of community property has been rebutted. That house is actually his separate property, not community property, even though he was married. Since he acquired it before the marriage, the presumption is rebutted. It was his separate property. Here's another example of rebutting the community property presumption. What if in that same example, the house was acquired during the marriage, but they didn't buy it. The husband and wife didn't buy it. Let's say the husband had inherited that house. So even though it was acquired during the marriage, if it was acquired by the husband as a gift or as an inheritance, then again, it would be his separate property and not the couple's joint community property. We're talking about these details because the details really, really matter. Because let's say we're using the example where the husband who died had a valid last will and testament, and his will says, I give everything to my children and not to my wife. We need to know what is community property versus separate property so we can say what is everything. because he can only give away his half of the community and he can only give away his separate property. So those details are super important. I'll give you an example. Let's say the husband had acquired the house during the marriage by gift or by inheritance. Well, then in his will, he can give away all of the house to his children to the exclusion of his wife. On the other hand, let's say the husband and wife acquired the house through their money that they had earned together during the marriage. When he says, I give everything to my children, everything only would include his community half of the home. He can't give away what doesn't belong to him. The surviving wife had her half in the community house. And so he can't give away her half. That's hers to do. So again, these details and these presumptions are really important. And you know what? It gets a little complicated. And that's why oftentimes judges and attorneys get it wrong. And definitely the public gets it wrong. In fact, I would say most people get it wrong. So all the time we have usually surviving widows. They come into our office and they say, you know, Isaac, I need to deal with getting the title to the house in my name. My husband's passed away and I should inherit everything automatically. And we go, okay, well, let's dig a little bit deeper here. You acquired the house during the marriage? Yeah, we acquired the house during the marriage. Okay, great. Did you acquire that by a gift? Was it gifted to you? Was it gifted to your deceased husband? How, you know, what was the source of the money to purchase that property? Because that's an important detail, as you know. And so as we get through those details, sometimes we learn that that property isn't community property, or it was the husband's separate property. Or let's say it was community property. We have to tell this poor widow that, well, his will says his half goes to his children and not to you. And so you're not going to inherit his half automatically. Well, I've rambled enough. I really need to get to the moral of the story. So let me just break it down again. The moral of the story is when you're married here in Texas and you pass away, the legal presumption is that everything you own is community property. And community property is 50-50. Half to the husband, half to the wife. That's what community property is. But that's just a legal presumption, and that legal presumption can be rebutted. And it can be rebutted by evidence that, well, what if one of the spouses acquired the property prior to the marriage? Well, then it would be separate property. What if the property was acquired during the marriage, but by gift or inheritance? Well, then again, the presumption of community is rebutted, and it would be that spouse's separate property. And these details matter because when we go to probate a will and that will says, I give everything to a certain person, we need to know what is everything. Because if it's community, you only have half. The deceased only had half. If it was his separate property, then he has the whole. And so those details between community and separate property mean a lot when it comes to probating a last will and testament when a person passes away. Now, I want to just really wrap a bow on this and describe that these are the default laws here in Texas. And those default laws really don't matter if that couple have come together to do their really good buttoned up estate planning. So an attorney like me, when we sit down with a couple on the estate planning side, we'll talk about these community property issues and we'll talk about the differences between having a last will and testament and doing a trust, because a lot of times couples don't want the default laws to apply to them. And they want to have control over where their assets would go when they pass away. And so those presumptions don't matter if you have estate planning done by a lawyer. So again, I think it's important for people to know what the legal presumptions are, not just if you've lost a loved one, but also because if you're a married person, you should be thinking to yourself, Should I do some estate planning? Should I do a trust with my spouse? Should we do wills together? Might we meet with an attorney together? Because these defaults and these presumptions, they only matter if you haven't done good, proper estate planning. If you've done good, proper estate planning, then those default laws don't apply to you because you've taken control. You get to decide what would happen to your assets when you pass away. And by the way, getting your estate planning done, whether that's a will or a trust, almost always costs less and is easier than what our clients would have thought. So you really don't have a good excuse not to go see an estate planning attorney if you are married. Go see one, you'll be pleasantly surprised. Now, on the other hand, if you have lost a spouse or you've lost a relative who was married, it's important for you to know these presumptions because here's a little shocking gotcha. In that situation where I talked about the different assets, and I included some accounts. Well, sometimes we represent the surviving children or child of a deceased husband. And sometimes that surviving wife has accounts in her name. Well, it doesn't matter that checking account has only her name as the owner on the paperwork with that account. The legal presumption is that it's community property. So these accounts that the surviving widow thinks are all hers may actually half be community property of the deceased husband. And it may not matter what the top of the check says because if there's the legal presumption that it was community property, his will may say that it goes to his children. So the moral of the story again there is go see an attorney because what I just said isn't intuitive and is shocking to almost everyone. And only guys like me, people who've handled many probate cases here in Texas, would know little details like that, but they're details that are hugely important. So the moral of the story is if you're thinking about estate planning or if you've lost a loved one who was married, go see an attorney. It's probably well worth the expense and the time.